All right, if you are gearing up for the bar exams, or if you're a law student or legal practitioner, you're definitely going to want to lean in for this one. Today, we're diving into a really monumental En Banc Supreme Court decision. It was penned by the current bar chair himself, Justice Gaiarlan, and it tackles the incredibly complex and highly debated taxation of Philippine offshore gaming operators, or POGOs. It is an absolute goldmine for constitutional and tax law doctrines, so let's get into it. Here's a quick roadmap for today's explainer. We'll be walking through the POGO tax dispute, petitioners versus the government, the one subject rule, situs versus privilege tax, the En Banc decision itself, and finally, those all-important key bar exam takeaways. Okay, starting with part 1, the POGO tax dispute, and setting the stage for this massive legal showdown. To really grasp the constitutional stakes here, we've got to rewind a bit and look at the sequence of events. Way back in 1983, the PHCodal charter was enacted. Decades go by, and then in 2017, the Bureau of Internal Revenue tries to impose a 5% franchise tax on POGOs. Fast forward to September 2020, right in the thick of the pandemic, the Bayanihan 2 law is passed as an emergency response, and it actually embeds taxes on POGOs as a funding mechanism. This rapid escalation quickly forced the Supreme Court's hand, leading them to issue a temporary restraining order in January of 2021. Now, bar takers, highlight this in your mental notes. The POGO rules define offshore gaming as games offered exclusively to offshore authorized players. The physical location of the players and the games themselves becomes the absolute crux of the tax jurisdiction issue we're going to talk about. So offshore gaming essentially boils down to 3 core elements. There's a prize, there's a non-Filipino player located completely outside the Philippines, and the winning is decided by chance. The most crucial point to remember here is that literally none of these 3 components actually occur within Philippine territory. Keep that firmly in the back of your mind. Moving right along to part 2, petitioners versus the government and the real clash of legal doctrines. We've got 2 completely opposite corners in the ring here. On one side, the petitioners, these are the offshore-based POGOs, argue that the Bayanihan 2 law provisions are unconstitutional riders. They also claim it violates the basic territoriality of taxation, since their income is sourced abroad. On the flip side, the government counters that Bayanihan 2 is a perfectly valid funding mechanism. They argue, hey, we aren't taxing income based on location, we're taxing the privilege of exercising a franchise. That brings us to Section 3, the one subject rule, and how it applies to the Bayanihan 2 law. This leads us to the exact constitutional question the Supreme Court had to wrestle with. Did Congress essentially slip an invalid tax measure into a critical emergency pandemic relief bill? Well, to answer that, we first need to define what a rider actually is. A rider is a legislative provision that is completely alien or just not germane to the main subject of a bill. The whole constitutional rationale against riders is to prevent hodgepodge or log-rolling legislation. It ensures that the public and the lawmakers themselves are fairly apprised of the exact subjects being voted on. The core nature of the law is heavily emphasized in this case. The Bayanihan 2 law was explicitly designed as a temporary stopgap stimulus measure to fight a global pandemic. It was never intended to be a permanent tax statute that creates brand new tax liabilities out of thin air. And Justice Gaiarlan caught a pretty glaring contradiction in the statutory text itself. The law explicitly states that even after the COVID-19 threat is successfully contained, these franchise tax collections shall continue to be collected and accrue to the general fund. So the clear intention was for these new taxes to perpetually outlive the temporary pandemic relief measure they were attached to. All right, let's pivot to part 4. Situs versus privilege taxation. Where does the income actually originate? This forces us to ask a really fundamental question. Are these offshore POGOs actually doing business inside the Philippines, and are they enjoying state protection that justifies them being taxed in the first place? In tax law, the source of income is the specific activity that produced it. As we know from the landmark BOAC and Baier-Nickel cases, the source isn't just where the cash is physically received or dispersed. Instead, the real test is where the business activity actually takes place. Putting these 2 opposing doctrines side by side makes the issue crystal clear. For situs of income, the activity, meaning the bets, the games, the payouts, happens entirely abroad, so no income is derived from sources within the Philippines. The government tried to counter with the privilege tax argument, which, admittedly, doesn't rely on situs. However, a privilege tax still fundamentally requires a valid, pre-existing law enacted by Congress. You can't just tax a privilege without a statutory basis. So, how did this all shake out? Let's get into Section 5, the En Banc decision and Justice Garland's ruling. First off, the court struck down the BIR's 2017 issuances, ruling that the taxing authority definitely overstepped its bounds. Think about it. The 1983 PAGCL charter only granted tax privileges to physical brick-and-mortar casinos. Back in 1983, it simply could not have contemplated borderless online gaming. Because of that, there was absolutely no underlying statute taxing POGOs before Bayanihan 2 was passed. Consequently, Sections 11F and G of the Bayanihan 2 law were struck down. The En Banc ruled that they were unequivocally unconstitutional riders. As the court pointed out, Congress cannot camouflage brand new tax legislation inside a temporary emergency pandemic relief bill. It just doesn't fly. So for your case digests, and you'll definitely want to write this down, here is the definitive ruling. The Bayanihan 2 provisions, unconstitutional riders. The BIR RMCs lacked statutory basis and encroached on legislative power. Furthermore, applying traditional tax tests, offshore POGOs derive no income within the Philippines, and legally speaking, they are not doing business here. The tax provisions were declared completely void. Finally, let's wrap up with Section 6, key bar exam takeaways and how we apply these doctrines. Now, the year 2021 is a super interesting footnote to all of this. That's when Republic Act 1150/90 was passed, which officially and legally taxed POGOs. Technically, this new law actually mooted the very case we just spent all this time discussing. But the Supreme Court utilized the capable of repetition yet evading review exception. They chose to rule on it anyway, knowing it was absolutely vital to establish these permanent constitutional guidelines for the bench and the bar going forward. I also want to touch on Justice Perlis Bernabe's separate opinion because she highlighted a massive modern challenge: taxing the digital economy. Traditional tax laws really struggle with the unprecedented mobility of users, cross-border data reliance, and these multi-sided digital business models. The court made it abundantly clear that to tax the digital economy, Congress has to enact specific modern legislation. You can't just stretch outdated, decades-old statutes to fit new tech. And that leaves us with a truly provocative question. How exactly will our laws continue to adapt to a borderless, ever-evolving digital economy? We're going to see a lot more of this in the future, for sure. If you found this explainer helpful for your legal studies, your bar prep, or just your general knowledge, please make sure to hit that like button, drop a comment below with your thoughts, and subscribe for more in-depth legal breakdowns. Catch you in the next one.